It's Lisa from Been There, Got Out. And as promised, we just got off a call. Today's guest is Florida attorney Heather Quick. She's the founder of Florida Women's Law Group, and we are going to talk about everything we can squeeze in to that has to do with discovery and the discovery process. There she is. Discovery is one of those things that can feel paralyzing to those of us in really difficult cases. So let's see. So Heather, I don't see you coming on, but there's another camera requesting to be in the video. Let me, I don't know who that is. I don't know if they're related to Heather. Let's see. I got it. I think we're going to make this happen. I hope we're going to make this happen. Uh-oh. Okay, let's try it again. If it doesn't work in the next few seconds, you know this always happens.
Yay.
All right, what a relief. Hi, Heather.
Hi, Lisa. Oh my goodness, thank you so much. Yeah, I was like worried. The technology, right? That's always what it is.
I know, but it doesn't matter. Here you are. So before we even get into who you are, how common is discovery in divorce cases? Like, is discovery always necessary?
Yes, I'm gonna say yes, it is, and to the degree that it is needed does depend on the parties and their financial situation. But I mean, generally that is a yes. And here in Florida, they are going to require certain you to acknowledge that you are aware and have been advised of your financial situation, just to, sometimes try to agree and get things done. But generally it's very clear that yes, you need to both be on equal footing, like you both know what is there. And not only the money, but what is the nature of it? Not all assets are the same, not all debt is the same, and that you have a good understanding. So the parties are going to have to basically swear that they know that, sign off on that. So it's really important that you do it.
Yeah. Okay. So before we even get into what discovery means, Heather, can you officially introduce yourself?
Yes, absolutely. I am Heather Quick, owner of Florida Women's Law Group. We are a divorce firm for women only, with all women attorneys in the firm and women staff. And I've been practicing for 25 years now, and the majority of my practice has been family law.
Okay, wonderful. We have a lot of clients in Florida, so I'm glad and hope they find you. So what actually does discovery mean? Because I think we always think about financials, but I think it might be broader, especially when it comes to custody issues. But legally, what does that mean, discovery?
So basically, discovery, I think the easiest thing is to say, if you want it, you get it. And that's what discovery is. So basically, you want to discover it, ask for it, and you're probably going to get it. And so that is just generally, because you're right, we start with the financials because that's just the basics,
Mm-hmm.
the basics of what it is. And then that can be, very complicated depending on the assets, businesses, things like that, but maybe very simple on the financials, just very straightforward. We're both W-2 employees. We don't have businesses. We don't have a bunch of other accounts. It's, very apparent through that what it is. But then, like you said, there could be custody issues. So then you may have videos, you may have voice recordings, you may have things, your child has written, anything you can kind of think of that may exist, you ask for it. That's how you discover what's there. And that's why very often we do a large blanket request
Mm-hmm.
in the beginning, because we might not know that exists. You might not know that your spouse has been keeping all these, secret recordings or the ring recordings and has a bunch of information. So we ask because then with the rules, and this is, I'm sure, within all states, like if you say it doesn't exist,
Mhm.
and then later try to use it, they're going to most likely be prohibited. I
That's
mean,
great.
yeah. So that's why it's so important, because we don't know what we don't know, and even you, like, what have they kept? And I know many people going through a divorce. Well, he's gonna lie anyway. Well, okay. I do start with that premise that mostly everybody's gonna be lying.
Mhm.
However, we need to use the rules of procedure and the laws to your benefit to protect you if we can. So that's why that's important, to ask for that.
Yeah, I know those big blanket requests are terrifying. And sometimes people get asked for really strange things that they never thought about. Like I know in my own discovery of our divorce, my ex's attorney was asking for things from before we were married. Journals. I mean, I've been journaling since I was 12. They wanted all of my journals. They wanted all of my emails that ever mentioned my ex's name. It was just like the privacy issue, scheduling, like just agendas, like a paper little calendar. They wanted that. My lawyer said, you're going to have to give it. And I felt like it was such an invasion of privacy.
And that's true. It is. And so generally we start with like a wide net. And that's why it's up to your attorney to help you understand. Okay, I would, just from that basic information, it's like, okay, well, we're going to object and say that is too broad, overburdensome, and really harassment to ask for premarital things on journals. A lot of time, premarital financial is very important because there may be claims that, this is my premarital money, and so we have to separate what's marital. It's not 100% marital, and
Mhm.
so that can be very relevant. But that's the key: how broad, right? Because everybody's heard on the TV. Yeah, I'm a Law and Order junkie. Like, I still love it,
Yeah.
And then they're like, oh, they're going on a fishing expedition, Your Honor. Okay. Well, that does get said, and sometimes you're like, that's the only way we're going to find out. And then that's going to really be dependent on your judge, because in some cases they're like, we're not going to say you can go get 5 years worth of all of these things
Mhm.
from this person. But sometimes, yes, that's in a lot of those blanket requests, it goes back 5 years. So we try to be very intentional with those big requests to start, because see, then if in 3 years and we see something,
Mhm.
now we have a basis to specifically say, I want this. But it's more, it's easier just to send it all, but then you may have a objection. So sometimes we want to be very intentional. It's not that, and then also some people be like, all right, well, come to the lawyer's office and copy it all, and they just fill the room with boxes
Mhm.
to kind of lose you in that. So
Oh,
that's why
expensive.
I know it is. And so you really want to be strategic and intentional based on the issues in the case. And that's where it gets specifics. Like, what are the issues? Are there a lot of financial issues? Are there a lot of children's issues? And so then where do we go? Who do we need to talk to? What records do we need to see?
Yeah, and as you're talking about the 5 year thing, I'm thinking about something another lawyer referred to as instant poverty syndrome, where just as you're getting divorced, your ex or your spouse suddenly is unemployed or they had a terrible year. And so going back for several years in terms of wages and income could be helpful because it establishes a precedent. And then if there's a vocational analysis, where somebody is looking at what someone is able to make, they can use more information rather than just those 3 years. Like during COVID, many people's jobs changed, right? So
Crazy, right?
yeah,
And some people made a lot more money during COVID, and some
right.
people didn't. And so we didn't want to just use that year because, that was like, such a crazy time, but it's a very good example. And for the person who maybe really, like, their business was very profitable during COVID, but then dipped down, they would want to show, okay, well, that's not going to be the long term, right? Because then the demand is going to go down. Or, before COVID, this is what they were making. And those are the kind of conversations that are so important with your attorney, right? What has happened, in the marriage, in the situation that we look at. And I'm sure every state has, not only the norms, but your attorney should know kind of what is the judge going to do. Ours is, without a doubt, 3 years. It's through case law. Like 3 years is very relevant, but that's why I said that should lead you to something else if you need something further than that. And many times we do, but for a lot of individuals, 3 years is fine. That gives you a good understanding, and that's the other thing that's so important as someone going through a divorce. They may not fully understand, appreciate the assets, the costs, that it costs them to live, maybe, what their spouse makes. So that's also why that's so important. So that you understand and appreciate that to then make an educated decision. So then especially if you're settling, which, is usually in most individuals' best interest if they can, but you need to know, right? That's what I tell our clients, and we all tell them all the time, like, it's okay. You can decide whatever you want, but you need to understand this is what's there, because you're going to have to sign a document saying, I know this is there and I still don't want it, or likewise, that's why that's important, because these contracts, as you know, and these divorce agreements, you're not going back and changing the financials. Like, that's just not happening. So you need to be sure and just that you are making a good decision with the knowledge, right? And then you can walk away from whatever, but as an attorney representing you, we just need to know that you appreciate that. And that's fine. You're like, I don't care, I'm walking away. Okay, you have a right to do that. You just need to know what you're walking away from.
Yeah,
And
when
fully.
you're making me think of the term like informed consent.
Yes.
So everyone is entitled to full, transparent financial discovery, and they can make their own choices. But I think in our community, a lot of people are in these relationships where the power dynamic is not balanced, and their ex will say, you already know what I have. Let's not waste all this money with attorneys. You don't need to see, like, I'm of course going to be fair to you. And
Yeah.
let's not prolong this and make our clients feel like they're the ones causing problems by requesting discovery. What's your
Yeah.
opinion on that?
Oh, I
You see
think
that?
that's a very common tactic. And I remember, and this is so many years ago, the husband's attorney, who was a colleague of mine, we had done a lot of cases together. He's like, oh, Heather, he just really wants this to be, a consent, and they're agreeable. And I was like, well, I'm not saying she doesn't, but why isn't she entitled to an attorney? He has an attorney. Like, and I remember he's like, you're right. I was like, I'm hired to do what our client asks us to, but that's protect her interests and make sure that she's making a good, informed decision. And that is so often the way it's portrayed, right? The husband's like, no, you go hire an attorney, then it's going to be all contested, and
Yeah.
just trust me, I'm going to always take care of you. Well, okay, you guys are divorcing, so take that for what it is and just be smart. Why does he get to be smart and have the attorney and know everything and you don't? And him doing it is not adversarial, but all of a sudden you doing it is. Like, that doesn't make any sense.
Right.
Right? You're exiting this, and it's a legal proceeding. You have rights, you have responsibilities, and you need to be smart. And you can be smart and not adversarial. That's the presumption. I think so many men tell their wives, like, oh, don't make this so hard. Like, then the attorneys are going to take everything.
Yep.
I mean, you get what you pay for. There is obviously a wide range of, litigation that we know, years and thousands and hundreds of thousands of dollars. However, that is not in our cases, that's not the norm.
Mhm.
Like, right? Like if, we're just trying to, thoughtfully exit this marriage, but in a fair way. And for the woman who doesn't know everything, like, shame on you if I tell you we should look at this and you should make an educated decision, because now you're going to be on your own for the rest of your life. So he may be telling you all this stuff, but he's no longer going to be, a part of that. You should be smart about that. And why does that have to be wrong when all of a sudden, a woman who may not have been a participant in the finances, who may not know, why is that wrong for her? And why does she not have a right to do that? And I think, that oftentimes those emotions and that coercive behavior, it does. It makes you afraid. And we try to help educate women that's just not true. He is making you feel that that's the way you're going to be, but you're looking out for yourself because you're going to be on your own after this.
Yeah, and I love how you said it's about knowing your rights as well as your responsibilities. Because sometimes we meet people and they've signed agreements and they're like, I didn't know that this was going to happen. And
Yeah.
part of what we teach our clients is to do what's called take strategic oversight of their case and realize, like, you can't just hire a lawyer and think they're going to take care of everything and save your life. Like, you need to stay on top of things. You need to read everything. You need to understand what you're signing. And if you don't understand, you need to ask before you sign, because you can't then blame someone that you didn't know what you were doing. That's why they always have these checks of, like, do you have counsel? Do you understand what you're signing? Do you agree that this is what you really want to do, to make sure that nobody changes their mind? But it is important to acknowledge that pressure from the dynamics of the relationship of feeling like I don't even have the right to ask.
Yeah. And also, for your listeners and things, I get it, because you might feel pressure from your attorney, which
Yes.
isn't good. And you need to voice that. Like, I feel like you're pressuring me. I need space. I need time to process. You got to advocate. Like, we are your advocate, but we can't read your mind. And you have got to also advocate for yourself, because again, this is your life. And if you are overwhelmed, and I will tell you, mediation, we do mediations where it's just a full day. I've had lots of people on the podcast, and they'll do it in increments along the way, but that can be a lot. It can be 8 to 10 hours. And yeah, we go in knowing all these decisions, but that's a huge, exhausting day. Like, really, almost decision fatigue. Like, you've made so many decisions. And
Yeah.
if, I will say, like, I'm extremely intuitive. Like, I can be like, I don't think they should sign, and I'll say, I don't think you should sign. And I'm not trying to impasse the whole day. I'm just saying, this person needs space to sign. We're not, like, don't say, oh, we all leave here without signing, everything's off the table. Now, people may say that, but in the reality, the majority of, at least the lawyer, the community like, well, that would be a waste for both of these parties. But, it's really helpful to know that, like, and your attorney just may not see that or read that in you, that you just need a little bit more time. And those are great conversations to have, especially if there's going to be a mediation, a big settlement negotiation. You hear it a lot where the client's like, I was just ready to go, I was done, but they signed it, and now it's a contract, and the court's gonna say, well, your lawyer was there, he had a lawyer, like, you understood. And so that's why, again, yes, your lawyer is there to advocate for you, but you've gotta be your number one advocate in that process, and hopefully that's a good communication with your attorney. But when these decisions get overwhelming, never believe, oh, we can change it later. Don't ever
Yeah.
fall for that.
Yeah. A number of our clients' attorneys have said to them, let's just finish this and you could always go back later. And we're like,
No,
no.
it's not true. And who wants to set yourself up to go later? Like some
Right.
things that happens, but no, that's I have heard that from many clients.
Yeah.
Well, they just said I could change it later, and I'm like, no, there are some things that cannot be changed,
Yeah.
and
Like,
the
why not get it
burden
right now?
and the burden to change is like it's just sometimes that can be more of an investment in time and money to
Yeah.
try to change than the original proceeding. So yeah, it's just so important to really understand that you need to feel confident in what you're doing, and you may be making compromises. Okay, like that's how we get things done sometimes, and but that you understand, right?
Right.
Like I always try to tell clients like, okay, if you want things maybe in a settlement that you might not get in court, so there is a give and take, and
Mhm.
recognize that that is the way it goes, but you got to participate in that and have closure. Because as we know, when you go to trial, yeah, there's closure, but there's just a decision by not you. And sometimes when, you have a husband that is completely unreasonable, and I've had those cases, we got to go to trial. And it's like, you're going to be better off. Like, and that's where you need to have the trust of your attorney to understand, what will likely happen.
Mhm. Yeah. So, something you were saying before, and I wanted you to focus on a little bit, was some of the objections to discovery requests. So you said broad, burdensome. Can you go into a couple of common ones, like
Yes,
reasons
so
to object?
we will always say like, "Oh, that's irrelevant," because that's our favorite objection, right? Everybody's
Yeah.
heard that one, and so we will, and like you said, like journals from before your marriage, we're gonna say that's irrelevant, and we're
Mhm.
gonna try to, and it's being done to harass and embarrass. Because that may not be the legal objection, but we're just trying to show to the court this is, harassment. Overbroad is a really big one and as well. And then, oftentimes we'll claim privilege and with attorney-client privilege. So we may have, worked with the client and we may be compiling some things, but it's under the work privilege is what we're going to assert. And that can be tricky. Most states, follow those same kind of evidentiary things, but um, that's a common one. And also, same with medical records. And that is a big one.
Mhm.
A lot has changed in my 20 plus years of practice as far as having more protection over your medical records and your mental health records, because that's another one. I mean, your spouse knows you've been seeing a therapist. They're going to be like, I want those records. So that's not as automatic. You want somebody who's going to make them, really fight for it. They may get it when there are children at issue, but you don't want to just hand those things over.
Mhm.
And generally speaking, most therapists, doctors, they're not going to. They're going to require a court order that is trying to do that. And sometimes they still can say HIPAA because HIPAA is federal and you're dealing with your state. So there's a lot of protections there for you. But then I also would say, you know, trust your, I hope you need to have an attorney you can trust and say, because you know why they're doing it. Like
Right.
this is what they're looking for. Okay, let's talk through this, right? Because how much is it worth fighting over or not? But those are very common ones for sure. And a lot is it's overburdened. It's overbroad but burdensome. If we wanted 10 years of your business records, I mean most businesses should have them, but they're going to say that's too much. You can't
Mhm.
go and do all that. So that's where you want to be narrow and then build on it. But those are some general objections.
Yeah. What's the one where they already have it? They already have access and they're asking for something they already have.
So, well, and that one is just, it's overburdensome and they have equal access. And that's usually what, if that's your only argument, but you've got it too, just give it. Like sometimes just
Yeah.
going to court to fight costs you more money.
Uh-huh.
And at
That's
the end
that's
of the
important.
day,
That's important to think about because it's
it
just
is.
costing
It's
money to
just,
fight it.
is it worth it? Like, and so I think those are really good conversations that you should have with your attorney. And that's why it matters when are you guys on the same page, right? Is this an attorney who's just going to fight everything? And you may feel really good about that, but then it's like, but then that's a lot of money. And so
Yeah.
let's be smart and, like, it's kind of like that, pick your battles. Let's see what will end up happening. And oftentimes, I know like clients get frustrated because their attorney may say, listen, this particular judge, this particular issue, this is what I foresee happening. So I don't think that would be money spent, and I don't think we're going to prevail. It's those are conversations that you should be having on what to object to and when. Because
Mhm.
if you just are saying no to everything and always in front of the judge, now they're going to be like, all right, you're just being an obstructionist.
Yeah.
You're
Yeah.
just trying to keep the process from moving forward versus having valid reasons. So that's where you gotta, figure that out, that balance.
No, it makes sense and always to be conscious of how much money am I spending to get a point across.
Yeah, and at the end of the day, is that really, is that worth that expense?
Yeah. So what we see with a lot of our clients, because all of them are dealing with really high conflict and domestic violence, is they get paralyzed with discovery requests. They just are like, I can't look at it, I can't do it. And their lawyer's saying, you need to get it to me like this week. How do you deal with clients who are just paralyzed with terror?
It's really hard because we are empathetic to that. I recognize that, and it's overwhelming. They've never, been in the legal system, and yet they're like trying to separate themselves from this high conflict relationship. Sometimes, often very controlling, and they feel like I don't know where any of this is. So we really work with our clients from the very beginning. This is everything we need because we know what they're going to ask for, and really try to do it in smaller chunks because for some people they can receive this 25 numbered request and be like, okay, I know where everything is or not. And
Mhm.
some will just be paralyzed. Like, I don't even know where to start and where would this be. So we do try to break it down and work with them. These are the things you need. Are they in the house or are they, but things are like, back when I was practicing, people had their filing cabinets and all their paper. Nobody has any paper anymore. And so some things are, electronically kept and unavailable, right? You may not have the password. And bank statements are the most common, and very few people get bank statements mailed to them anymore. However, you can go to your bank and ask them to print them. And so that's what we'll just say: just go and get them printed because we probably need those more for you to educate yourself
Mhm.
on all the money coming in and out of the household if it's a joint account. And that's just faster than us waiting on things. We'll often, help our clients request the tax returns because maybe they're like, I have no idea where they are. It's
Yeah.
electronic.
Mhm.
I don't remember signing it. Try to break it down to those things and help them because part of this process, the way I see it is what I talked about earlier. You're going to be on your own later. So let's start trying to do things that are empowering you to make these decisions. You don't have to remain a victim. You may feel like you don't have to, and you can you can do these things for yourself. And we try to guide them on how to do it.
Yeah, that's great. I mean, that's what we try to do too, is like we want to teach you how to help yourself. Like you will be able to do this
Yes.
yourself. So this is really an opportunity with you as a lawyer is like, let's start getting you ready to take care of certain things by yourself. All right,
Yes.
I want to talk about the flip side of discovery when it's our client's ex who is not complying and they're getting extremely, and this was me too, like so frustrating. Why do I have to comply with everything? And my ex is not doing it, and nobody's like forcing that person to give me the
Mhm.
information I've been requesting like a dozen times.
Yeah, so that happens a lot. So several ways with which to do it. Understand if you are complying with your attorney and getting the things, that will make you very angry. We've heard it a million times. But like I said, we start at the very beginning once you hired us. So we've been preparing you. We are
Mhm.
helping, and usually, the client who's compliant is it doesn't want to like break the rules, and and
Right.
then your spouse like doesn't care at all and is like just gonna make me, work harder for it. A lot of ways we handle that. Well, one, we do have rules of procedure and cost money, and then usually you can get some of those fees reimbursed for those discovery issues. But oftentimes, there are ways that we can get it that will be faster and probably less expensive. Like let's just issue subpoenas. Those are not, we draft them, you get them served, and now we get the full document. So we're not just relying on that he's giving us these pay stubs. We got his full, employment record, or
And you can
we're
subpoena
getting,
like a bank, not just the other person.
yeah, the bank, subpoena the bank, subpoena his company, subpoena those things, the credit card companies, the banks, so that you get the full records. And at the end of the day, that to me is of the right way to go. It's very direct. And the court's going to tell you and your attorney, well, you could have gotten him this way. Don't tell me like and I know that doesn't seem fair either. You're like, but he's supposed to give it.
Right.
I got it, but do we want closure and do we want the information to make decisions? Or do we just want to fight? And those are the conversations to have. And also, so subpoenas are very effective, and so are depositions. Um, because, with the discovery, we send it to them. They've got a month to respond. Okay, there's a month of your life, and then they want an extension. Okay, and so then let's just say we give them 2 more weeks. Now it's 45 days, and they gave us half the stuff we asked for.
Mhm.
So then you gotta then you have to ask again and do all these things, which can seems to anybody very wasteful and a lot of time going by. So those are conversations to have, is maybe just send us subpoenas, get the information that you need to make decisions. And also look at taking depositions of your husband or maybe other parties that may have the information that we're trying to get. And those are very effective tools that kind of circumvent the waiting and then saying, oh, you didn't do this. And
Tell us a
um,
little bit about depositions, like how those can provide leverage.
So it allows you sometimes, and for our listeners, we as your attorney, we can't just call up your husband and ask him all these questions, right? We got to go through his attorney, and most, every state has some form of this or another, a financial affidavit, which really outlays all your income and expenses.
Mhm.
It's required in every divorce, and sometimes it doesn't make sense, and you have a lot of questions about where this money's going. Instead of that, I mean, you can ask for all the supporting documents on that, but you could also just schedule a deposition and ask the questions you want answers to. And in the way you do that, is say, and then they'll say, I can get you that information. Okay, can you get it for me in a day, in 10 days? And so now he's committed in the attorney. And so then if he doesn't, you go to court, he was under oath, he said he can get this, and he has that. And so it is a bit more effective, and it allows your attorney that interaction to see how are they going to answer the questions. Are they being very evasive and obstructive? And then that's going to be in a transcript for the court to see. But it can be a very effective way to have them say under oath, you know, why they're asking for the things they are asking for as far as the children's issues. You know, their lawyer wrote all their pleadings and they signed them and okayed them, but maybe they can't really give you good answers to back up the things they're asking for. So, and sometimes they can, and that's also good to learn, right? It's good for your attorney to see how they're going to react in this situation. Are they going to be difficult? You know, are they going to be, you know, productive? Most depositions, it can be a very different, you know, some can be very adversarial. And, you know, the lawyers, when you're doing that, have a tactic, but most of the time it's just getting information. I'm just asking you questions that I can't do unless we do it in that setting.
And that's cheaper than going to trial.
Absolutely. And not, you know, and it's the time spent when preparing for it and attending it. But then if you do end up going to trial, you can get that transcript, and now everything that was said under oath, that was under oath. So then if they lie later or they were lying then, and you can catch them, and then that, you know, does affect their credibility in front of the court. So it's a very effective tool. It's not necessary in every case, but it's very helpful in a lot of cases.
Yeah, that's great to know. And also, you're not on the court's time where there's other cases that a judge is seeing and you're waiting to have your turn. Like you can schedule that on your own time. So you already know how long it's going to take. It's not a full day in court.
Absolutely. Yeah, and it's and it's just and sometimes also, you know, we were talking about discovery and all those things you want to know. That's an effective, you know, to take a deposition of someone else that, you know, maybe a critical witness that they're saying knows all these things. So, well, maybe we want to see what they're going to say. Is that going to be helpful to them, harmful to you? You know, you want to know that. It helps you make better decisions. To know what people are going to say. How's that going to affect your outcome?
Yeah. I'm as you said that, I'm like, that sounds like the theme of this whole conversation is how discovery helps you make better decisions.
Yes. And if you can look at it that way, I mean, it's not fun. Okay, nobody wants to gather all their
Yeah.
documents and years, and nobody wants to do that. I get it. But yeah, it's important. And I mean, most of the courts are pretty strict on it. It's like, it's just open. Like, this is what you got to do. Just do it. Right. Like that. And sometimes you'll see the judges here in this area of Florida, you know, all the judges do that are in the family law division. I mean, this is what they're doing all day long. And so that's kind of the thing where they're like, this is the basic rules. Like, this is the basic rules of the thing where we need to see tax returns, bank statements, pay stubs. Like, that's just your basic, not really arguable about.
Yeah.
Don't go arguing in that. And don't be obstructive, because then you're clogging up everything.
Yeah. Yeah. So that actually leads me into the next thing I was going to ask you. I love to ask attorneys, what kind of person is like your teacher's pet of clients? So how can our community be like the best client for their attorney where they're not clogging up the system? So besides what you just said, any other things?
So this is hard, but this is doable. Understanding that in general, like that financial documents, all those things, that's just the rules of the game. That's not personal. There is, and there's also that blanket big request. It's just a form in the state of Florida that lists out like 35 things. They were not specifically attacking you and trying to harass you in general, you know, based on that blanket one. If your attorney says, hey, this is what everybody sends, right? Then believe them, because that does happen a lot, right? That is general. And there are some things that usually are meant to get information. And sometimes maybe, your husband's attorney is like, oh, I really want you to go after and do this. And, some attorneys may, um, but ask your attorney, like, is this normal?
Mhm.
Or are they after something specific to me? Are they coming after me? And your attorney should be able to know that and understand, at least maybe recognize you know what you do know, but then you don't know this stuff. But could I get it? And what would that take for me just to go to the bank and have them
Mhm.
give that to me? And be willing to help yourself, really. The sooner you get the information, the sooner we can be moving forward.
So
It
it's
doesn't
almost like
mean I'm not.
putting aside the feeling of injustice, like it's not fair, they're supposed to be doing this. It would just be like, do what you have to do sometimes to get it done.
To keep, because at the end of the day, what is your objective?
Mhm.
Right. And that's a hard, sometimes it's hard, right? It's like, we want to be done. I want this information. And, okay, well, what other ways can we get it and to move forward? Because, and I have these conversations with my attorneys all the time. They're like, oh, we need this. I'm like, what do we need? Do
Mhm.
we really need it? What do you need to make a decision to advise your client? Because they want to be done, I'm pretty sure. And it takes a long time to process, even when it's going smoothly. So if we can, say, all right, well, you can get your tax returns and you can go to the bank. Let's just subpoena the employer and get the pay stubs, and boom, now we know everything we really need to know about the finances. And okay, yeah, he should have done better. All right, but you're divorcing him, or
Right.
he's divorcing you. So I mean, and people act in different ways, whether it's the client or your spouse, for whatever reasons, right? It's your life. It is emotional. I'm not going to say don't be emotional, because this is your life. It's very personal. It really is. And maybe they're just having a tough time with it too. Or they're thinking, if I just ignore it, it'll go away. I mean, that's kind of, a lot of humans do that. I've certainly done that in the past, on any
Yeah.
given day, like, oh, I'll just ignore it. It won't happen. So there's that. And not everything has to be a fight, even though and that whole thing, it's not fair. But this is the justice system, not the fair. So you
Mhm. Yeah.
gotta, and that is not what anybody really wants to hear, but that's the reality.
Yeah. Yeah. Well, I appreciate that. And we often say we give our clients, you're in Florida, but we call it the harsh New York reality check. Like, it is what it is. It's better to know what it is and operate knowing what it is. So
Yes.
Heather, how can people find you?
So they can find us, of course, on our website. That is FloridaWomen'sLawGroup.com. We also have a podcast, Women Winning Divorce, and we are on all the social media channels as For Women Law. So we are in all those places, and we're located in the Northeast Florida region.
Great. Well, I so appreciate you taking all the time to talk about this and enlighten us. And I look forward to talking to you again.
Thank you so much, Lisa. It was really a pleasure to be with you and have this discussion. Thank you so much.
All right. Take care.
All right.
Happy
Bye.
summer.